Limitation Act 1963, Act 36 of 1963. Part 1. Preliminary. Section 1. Short title, extent and commencement. Subsection 1. This Act may be called the Limitation Act 1963. Subsection 2. It extends to the whole of India. Subsection 3. It shall come into force on such date as the central government may, by notification in the official gazette, appoint. Section 2. Definitions. In this Act, unless the context otherwise requires, Clause A. Applicant includes Subclause 1. A petitioner. Subclause 2. Any person from or through whom an applicant derives his right to apply. Subclause 3. Any person whose estate is represented by the applicant as executor, administrator, or other representative. Clause B. Application includes a petition. Clause C. Bill of exchange includes the hundi and a check. Clause D. Bond includes any instrument whereby a person obliges himself to pay money to another on condition that the obligation shall be void if specified as it is performed or is not performed, as the case may be. Clause E. Defendant includes Subclause 1. Any person from or through whom a defendant derives his liability to be sued. Subclause 2. Any person whose estate is represented by the defendant as executor, administrator, or other representative. Clause F. Easement includes a right not arising from contract by which one person is entitled to remove and appropriate for his own profit any part of the soil belonging to another or anything growing in or attached to or subsisting upon the land of another. Clause G. Foreign country means any country other than India. Clause H. Good faith. Nothing shall be deemed to be done in good faith which is not done with due care and attention. Clause I. Plaintiff includes Subclause 1. Any person from or through whom a plaintiff derives his right to sue. Subclause 2. Any person whose estate is represented by the plaintiff as executor, administrator, or other representative. Clause J. Period of limitation means the period of limitation prescribed for any suit, appeal, or application by the schedule, and the prescribed period means the period of limitation computed in accordance with the provision of this Act. Clause K. Promissory note means any instrument whereby the maker engages absolutely to pay a specified sum of money to another at a time therein limited or on demand or at sight. Clause L. Suit does not include any appeal or an application. Clause M. Tort means a civil wrong which is not exclusively the breach of contract or the breach of trust. Clause N. Trustee does not include a benamidar, a mortgagee remaining in possession after the mortgagee has been satisfied, or a person in wrongful possession without title. Part 2. Limitation of suits, appeal and applications. Section 3. Bar of limitation. Subsection 1. Subject to the provisions contained in Section 4 to 24 inclusive, every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed although limitation has not been set up as a defense. Subsection 2. For the purpose of this Act, Clause A. A suit is instituted, Subclause 1, in an ordinary case where the plaint is presented to the proper officer. Subclause 2. In the case of a pauper, when his application for leave to sue as a pauper is made, and Subclause 3. In the case of a claim against a company which is being wound up by the court, where the claimant first sends in his claim to the official liquidator. Clause B. Any claim by way of a set-off or a counterclaim shall be treated as a separate suit and shall be deemed to have been instituted, Subclause 1, in the case of a set-off on the same date as the suit in which the set-off is pleaded. Subclause 2. In the case of a counterclaim on the date on which the counterclaim is made in court. Clause C. An application by the notice of motion in a high court is made when the application is presented to the proper officer of that court. Section 4. Expiry of prescribed period when court is closed. Where the prescribed period for any suit, appeal, or application expires on a day when the court is closed, the suit, appeal, or application may be instituted, preferred, or made on the day when the court reopens. Explanation. A court shall be deemed to be closed on any day within the meaning of this section if during any part of its normal working hours it remains closed on that day. Section 5. Extension of prescribed period in certain cases. Any appeal or any application other than an application under any of the provision of Order 21 of the Code of Civil Procedure 1908 may be admitted after the prescribed period if the appellant or the applicant satisfies the court that he had sufficient cause for not preferring the appeal or making the application within such period. Explanation. The fact that the appellant or the applicant was misled by any order, practice, or judgment of the High Court in ascertaining or computing the prescribed period may be sufficient cause within the meaning of this section. Section 6. Legal disability. Subsection 1. Where a person entitled to institute a suit or make an application for the execution of decree is, or at the time from which the prescribed period is to be reckoned, a minor or insane or an idiot, he may institute the suit or make the application within the same period after the disability has ceased, as would otherwise have been allowed from the time specified thereof in the third column of the schedule. Subsection 2. Where such person is, at the time from which the prescribed period is to be reckoned, affected by two such disabilities, or where before his disability has ceased he is affected by another disability, he may institute the suit or make the application within the same period after both disabilities have ceased, as would otherwise have been allowed from the times first specified. Subsection 3. Where the disability continues up to the death of that person, his legal representative may institute the suit or make the application within the same period after the death as would otherwise have been allowed from the time so specified. Subsection 4. Where the legal representative referred to in subsection 3 is at the date of the death of the person whom he represents affected by any such disability, the rules contained in subsection 1 and subsection 2 shall apply. Subsection 5. Where a person under disability dies after the disability ceases, but within the period allowed to him under this section, his legal representative may institute the suit or make the application within the same period after the death as would otherwise have been available to that person had he not died. Explanation. For the purpose of this section, minor includes a child in the womb. Section 7. Disability of one of several persons. Where one of several persons jointly entitled to institute a suit or make an application for the execution of a decree is under any such disability, and a discharge can be given without the concurrence of such person, time will run against them all. But where no such discharge can be given, time will not run against any of them until one of them becomes capable of giving such discharge without the concurrence of others or until the disability has ceased. Explanation 1. This section applies to a discharge from every kind of liability, including the liability in respect of any immovable property. Explanation 2. For the purpose of this section, the manager of a Hindu undivided family governed by the Mitakshara law shall be deemed to be capable of giving a discharge without the concurrence of the members of the family only if he is in management of the joint family property. Section 8. Special exceptions. Nothing in Section 6 or in Section 7 applies to a suit to enforce right of preemption or shall be deemed to extend for more than 3 years from the cessation of the disability or the death of the person affected thereby, the period of limitation for any suit or application. Section 9. Continuous running of time. Where once time has begun to run, no subsequent disability or inability to institute a suit or make an application stop it. Provided that where letters of administration to the estate of creditor have been granted to his debtor, the running of the period of limitation for a suit to recover the debt shall be suspended while the administration continues. Section 10. Suit against trustees and their representatives. Notwithstanding anything contained in the foregoing provisions of this Act, no suit against a person in whom property has been vested in trust for a specific purpose or against his legal representatives or assigns for the purpose of following in his or their hands such property or the proceeds thereof or for an account of such property or proceeds shall be barred by any length of time. Explanation. For the purpose of this section, any property comprised in a Hindu, Muslim or Buddhist religious or charitable endowment shall be deemed to be property vested in trust for a specific purpose, and the manager of the property shall be deemed to be the trustee thereof. Section 11. Suits on contracts entered into outside the territories to which the Act extends. Subsection 1. Suits instituted in the territories to which the Act extends on contracts entered into the state of Jammu and Kashmir or in a foreign country shall be subject to the rules of limitation contained in this Act. Subsection 2. No rule of limitation in force in the state of Jammu and Kashmir or in a foreign country shall be a defense to a suit instituted in the said territories on a contract entered into in that state or in a foreign country unless Clause A. The rule has extinguished the contract, and Clause B. The parties were domiciled in that state or in the foreign country during the prescribed period by such rule. Part 3. Computation of period of limitation. Section 12. Exclusion of time in legal proceedings. Subsection 1. In computing the period of limitation for any suit, appeal, or application, the day from which such period is to be reckoned shall be excluded. Subsection 2. In computing the period of limitation for an appeal or an application for leave to appeal or for revision or for review of a judgment, the day on which the judgment complained of was pronounced and the time requisite for obtaining a copy of the decree, sentence or order appealed from or sought to be revised or reviewed shall be excluded. Subsection 3. Where a decree or order is appealed from or sought to be revised or reviewed, or where an application is made for leave to appeal from a decree or order, the time requisite for obtaining a copy of the judgment shall also be excluded. Subsection 4. In computing the period of limitation for an application to set aside an award, the time requisite for obtaining a copy of the award shall be excluded. Explanation. In computing under this section, the time requisite for obtaining a copy of a decree or an order, any time taken by the court to prepare the decree or order before an application for copy thereof is made shall not be excluded. Section 13. Exclusion of time in cases where leave to sue or appeal as a pauper is applied for. In computing the period of limitation prescribed for any suit or appeal, in any case where an application for leave to sue or appeal as a pauper has been made and rejected, the time during which the applicant has been prosecuting in good faith his application for such leave shall be excluded, and the court may, on payment of the court fees prescribed for such suit or appeal, treat the suit or appeal as having the same force and effect as if the court fees has been paid in the first instance. Section 14. Exclusion of time of proceeding bona fide in court without jurisdiction. Subsection 1. In computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence another civil proceeding, whether in a court of first instance or of appeal or revision against the defendant, shall be excluded, where the proceeding relate to the same matter in issue and is prosecuted in good faith in a court which, from defect of jurisdiction or other cause of a like nature, is unable to entertain it. Subsection 2. In computing the period of limitation for any application, the time during which the applicant has been prosecuting with due diligence another civil proceeding, whether in a court of first instance or of appeal or revision against the same party for the same relief, shall be excluded, where such proceeding is prosecuted in good faith in a court which, from defect of jurisdiction or other cause of a like nature, is unable to entertain it. Subsection 3. Notwithstanding anything contained in Rule 2 of Order 23 of the Code of Civil Procedure 1908, the provisions of subsection 1 shall apply in relation to a fresh suit instituted on permission granted by the court under Rule 1 of that order, where such permission is granted on the ground that the first suit must fail by reason of defect in the jurisdiction of the court or other cause of a like nature. Explanation. For the purpose of this section, Clause A, in excluding the time during which a former civil proceeding was pending, the day on which that proceeding was instituted and the day on which it ended shall both be counted. Clause B, a plaintiff or an applicant resisting an appeal shall be deemed to be prosecuting a proceeding. Clause C, misjoinder of parties or of causes of action shall be deemed to be cause of a like nature with defect of jurisdiction. Section 15. Exclusion of time in certain other cases. Subsection 1. In computing the period of limitation for any suit or application for the execution of decree, the institution or execution of which has been stayed by injunction or order, the time of the continuance of the injunction or order, the day on which it was issued or made, and the day on which it was withdrawn shall be excluded. Subsection 2. In computing the period of limitation for any suit of which notice has been given or for which the previous consent or sanction of the government or any other authority is required in accordance with the requirements of any law for the time being in force, the period of such notice, or as the case may be, the time required for obtaining such consent or sanction shall be excluded. Explanation. In excluding the time required for obtaining the consent or sanction of the government or any authority, the day on which the application was made for obtaining the consent or sanction, and the date of receipt of the order of the government or the authority shall be counted. Subsection 3. In computing the period of limitation for any suit or application for execution of a decree by any receiver or interim receiver appointed in proceedings for the adjudication of a person as an insolvent or any liquidator or provisional liquidator appointed in proceedings of a company, the period beginning with the date of institution of such proceeding and ending with the expiry of 3 months from the date of appointment of such receiver or liquidator, as the case may be, shall be excluded. Subsection 4. In computing the period of limitation for a suit for possession by a purchaser at a sale in execution of a decree, the time during which a proceeding to set aside the sale has been prosecuted shall be excluded. Subsection 5. In computing the period of limitation for any suit, the time during which the defendant has been absent from India and the territories outside India under the administration of central government shall be excluded. Section 16. Effect of death on or before the accrual of the right to sue. Subsection 1. Where a person who would, if he were living, have a right to institute a suit or make an application dies before the right accrues, or where a right to institute a suit or make an application accrues only on the death of the person, the period of limitation shall be computed from the time when there is a legal representative of the deceased capable of instituting such suit or make an application. Subsection 2. Where a person against whom, if he were living, a right to institute a suit or make an application would have accrued dies before the right accrues, or where A right to institute a suit or make an application against any person accused on the death of such person, the period of limitation shall be computed from the time when there is a legal representative or the deceased against whom the plaintiff may institute such suit or make an application. Subsection 3. Nothing in subsection 1 or subsection 2 applies to suit to enforce rights of preemption or to suit for the possession of immovable property or of a hereditary office. Section 17. Effect of fraud or mistake. Subsection 1. Where in the case of any suit or application for which a period of limitation is prescribed by this Act, Clause A. The suit or application is based upon the fraud of the defendant or respondent or his agent, or Clause B. The knowledge of the right or title on which a suit or application is founded is concealed by the fraud of any such person as aforesaid, or Clause C. The suit or application is for relief from the consequences of a mistake, or Clause D. Where any document necessary to establish the right of the plaintiff or applicant has been fraudulently concealed from him, the period of limitation shall not begin to run until the plaintiff or applicant had discovered the fraud or the mistake, or could with reasonable diligence have discovered it, or in the case of a concealed document, until the plaintiff or applicant first had the means of producing the concealed document or compelling its production. Provided that nothing in this section shall enable any suit to be instituted or application to be made to recover or enforce any charge against or set aside any transaction affecting any property which, Clause 1. In the case of fraud, has been purchased for valuable consideration by a person who was not a party to the fraud and did not at the time of the purchase know or have reason to believe that any fraud has been committed, or Clause 2. In a case of mistake, has been purchased for valuable consideration subsequently to the transaction in which the mistake was made by a person who did not know or have reason to believe that the mistake has been made, or Clause 3. In the case of a concealed document has been purchased for valuable consideration by a person who was not a party to the concealment and did not at the time of purchase know or have reason to believe that the document has been concealed. Subsection 2. Where a judgment debtor has, by fraud or force, prevented the execution of a decree or order within the period of limitation, the court may, on the application of the judgment creditor made after the expiry of the said period, extend the period for execution of the decree or order, provided that such application is made within 1 year from the date of the discovery of the fraud or cessation of force, as the case may be. Section 18. Effect of acknowledgement in writing. Subsection 1. Where before the expiration of the prescribed period for a suit or application in respect of any property or right, an acknowledgement of liability in respect of such property or right has been made in writing, signed by the party against whom such property or right is claimed, or by any person through whom he derives his right or title, a fresh period of limitation shall be computed from the time when the acknowledgement was so signed. Section 2. Where the writing containing the acknowledgement is undated, oral evidence may be given of the time when it was signed, but subject to the provisions. Subsection 2. Where the writing containing the acknowledgement is undated, Oral evidence may be given of the time when it was signed, but subject to the provisions of the Indian Evidence Act 1872. Oral evidence of its content shall not be received. Explanation. For the purposes of this section, Clause A, an acknowledgement may be sufficient though it omits to specify the exact nature of property or right or avers that the time for payment, delivery, performance, or enjoyment has not yet come or is accompanied by refusal to pay, deliver, perform, or permit to enjoy, or is coupled with a claim to set off, or is addressed to a person other than a person entitled to the property or right. Clause B. The word signed means signed either personally or by an agent duly authorized in this behalf. Clause C. An application for the execution of a decree or order shall not be deemed to be an application in respect of any property or right. Section 19. Effect of payment on account of debt or of interest on legacy. Where payment on account of a debt or of interest on legacy is made before the expiration of the prescribed period by the person liable to pay the debt or legacy or by his agent duly authorized in this behalf, a fresh period of limitation shall be computed from the time when the payment was made, provided that, save in the case of payment of interest made before the first day of January 1928, an acknowledgement of the payment appears in the handwriting of or in a writing signed by the person making the payment. Explanation. For the purpose of this section, Clause A. Where mortgaged land is in the possession of the mortgagee, the receipt of the rent or produce of such land shall be deemed to be a payment. Clause B. Debt does not include money payable under a decree or order of a court. Section 20. Effect of acknowledgement or payment by another person. Subsection 1. The expression agent duly authorized in this behalf in section 18 and 19 shall, in the case of a person under disability, include his lawful guardian, committee, or manager, or an agent duly authorized by such guardian, committee, or manager to sign the acknowledgement or make the payment. Subsection 2. Nothing in the said section renders one of several joint contractors, partners, executors, or mortgagees chargeable by reason only of a written acknowledgement signed by or of a payment made by or by the agent of any other or others of them. Subsection 3. For the purpose of the said section, Clause A. An acknowledgement signed or a payment made in respect of any liability by or by the duly authorized agent of any limited owner of property who is governed by Hindu law shall be a valid acknowledgement or payment, as the case may be, against a reversioner succeeding to such liability. And Clause B. Where a liability has been incurred by or on behalf of a Hindu undivided family, as such, an acknowledgement or payment made by or by the duly authorized agent of the manager of the family for the time being shall be deemed to have been made on behalf of the whole family. Section 21. Effect of substituting or adding new plaintiff or defendant. Subsection 1. Where after the institution of a suit, a new plaintiff or defendant is substituted or added, the suit shall, as regard him, be deemed to have been instituted when he was so made a party, provided that, where the court is satisfied that the omission to include a new plaintiff or defendant was due to a mistake made in good faith, It may direct that the suit as regard as such plaintiff or defendant shall be deemed to have been instituted on any earlier date. Subsection 2. Nothing in subsection 1 shall apply to a case where a party is added or substituted owing to assignment or devolution of any interest during the pendency of a suit, or where a plaintiff is made a defendant or a defendant is made a plaintiff. Section 22. Continuing breaches and torts. In the case of a continuing breach of a contract, or in the case of a continuing tort, a fresh period of limitation begins to run at every moment of the time during which the breach or tort, as the case may be, continues. Section 23. Suits for compensation for acts not actionable without special damage. In the case of a suit for compensation for an act which does not give rise to a cause of action unless some specific injury actually results therefrom, the period of limitation shall be computed from the time when the injury results. Section 24. Computation of time mentioned in instruments. All instruments shall, for the purpose of this Act, be deemed to be made with the reference to Gregorian calendar. Part 4. Acquisition of ownership by possession. Section 25. Acquisition of easement by prescription. Subsection 1. Where the access and use of light or air to and for any building have been peacefully enjoyed therewith as an easement and as of a right without interruption and for 20 years, and where any way or watercourse or the use of any water on any other easement has been peacefully or openly enjoyed by any person claiming title thereto as an easement and as of a right without interruption and for 20 years, the right to such access and use of light or air, way, watercourse, use of water or other easement shall be absolute and indefeasible. Subsection 2. Each of the said periods or 20 years shall be taken to be a period ending within 2 years next before the institution of the suit wherein the claim to which such suit relates to is contested. Subsection 3. Where the property over which a right is claimed under subsection 1 belongs to the government, that subsection shall be read as if for the words 20 years, the words 30 years were substituted. Explanation. Nothing is an interruption within the meaning of this section unless where there is an actual discontinuance of the possession or enjoyment by reason of an obstruction by the act of some person other than the claimant, and unless such obstruction is submitted to or acquiesced in for 1 year after the claimant has notice thereof, and of person making or authorizing the same to be made. Section 26. Exclusion in favor of a reversioner or servient tenement. When any land or water upon, over, or from which any easement has been enjoyed or derived has been held under or by virtue of any interest for life or in terms of years exceeding 3 years from the granting thereof, the time of the enjoyment of such easement during the continuance of such interest or terms shall be excluded in the computation of the period of 20 years in the case the claim is within 3 years next after the determination of such interest or term, resisted by the person entitled on such determination to the said land or water. Section 27. Extinguishment of right to property. At the determination of the period hereby limited to any person for instituting a suit for possession of any property, his right to such property shall be extinguished. Part 5. Miscellaneous. Section 28. Amendment of certain acts. It has been omitted by Act 56 of 1974. Section 29. Savings. Subsection 1. Nothing in this Act shall affect Section 25 of the Indian Contract Act 1872. Subsection 2. Where any special or local laws prescribes for any suit, appeal or application on a period of limitation different from the period prescribed by the schedule, the provisions of Section 3 shall apply as if such period were the period prescribed by the schedule, and for the purpose of determining any period of limitation prescribed for any suit, appeal or application by any special or local laws. The provision contained in Section 4 to 24 inclusive shall apply only insofar as and to the extent to which they are not expressly excluded by such special or local laws. Subsection 3. Save as otherwise provided in any law for the time being in force, with respect to marriage and divorce, nothing in this Act shall apply to any suit or other proceeding under any such law. Subsection 4. Sections 25 and 26 and the definition of easement in Section 2 shall not apply to cases arising in the territories to which the Indian Easement Act 1882 may for the time being extend. Section 30. Provision for suits, etc., for which the prescribed period is shorter than the period prescribed by the Indian Limitation Act 1908. Notwithstanding anything contained in this Act, Clause A, any suit for which the period of limitation is shorter than the period of limitation prescribed by the Indian Limitation Act 1908 may be instituted within a period of 7 years next after the commencement of this Act, or within the prescribed period for such suit by the Indian Limitation Act 1908, whichever period expires earlier, provided that if in respect of any such suit the said period of 7 years expires earlier than the period of limitation prescribed therefore under the Limitation Act 1908, and the said period of 7 years together with so much of the period of limitation in respect of such suit under the Limitation Act 1908 as has already expired before the commencement of this Act is shorter than the period prescribed for such suit under this Act, then the suit may be instituted within the period of limitation prescribed therefore under this Act. Clause B. Any appeal or application for which the period of limitation is shorter than the period of limitation prescribed by the Indian Limitation Act 1908 may be preferred or made within a period of 90 days next after the commencement of this Act, or within the period prescribed for such appeal or application by the Indian Limitation Act 1908, whichever period expires earlier. Section 31. Provision as to be barred or pending suits, etc. Nothing in this Act shall, Clause A, enable any suit, appeal or application to be instituted, preferred or made, for which the period of limitation prescribed by the Indian Limitation Act 1908 expired before the commencement of this Act. Or, Clause B, affect any suit, appeal or application instituted, preferred or made before and pending at such commencement. Section 32. Repealed.